Assalamualaikum warahmatullahi wabarakatuh. Every good morning or evening to Madam Nik Nurul Fahana binti Sulaiman. My name is Muhammad Adam bin Hamzi, matric number 0747707 from group 3. Firstly, I want to introduce our members at a group 3. First, Muhammad Amir Aiman bin Rahaizat. Second, Muhammad Wafiuddin bin Jafri. Third, Muhammad Afham bin Muhammad Razali. And last but not least, Muhammad Aisyah Najmi bin Ahmad Sharul Nizam. So, we present about dissolution of marriage upon conversation of religion. Okay, let's start our introduction. Dissolution of marriage upon conversation of religion. In Malaysia, the conversion to Islam by one of the parties is a non-Muslim will result in a severe legal implication when a person embraces Islam. It not only involves a change of belief of faith, but the law that applies to it also change. So, in according to Malaysian law, personal law is divided into two topics. First, name personal law for Muslim, and second, self law for non-Muslim. For non-Muslim, the personal law that regulate matter of marriage and divorce that applies to them is the Law Reform Marriage and Divorce Act 1976. For Muslim, the law that apply to above them is Islamic law in each state. But important thing that become an issue, the question of embracing Islam, like this is when two different law are involved, name the Islamic family law and the 1976 Act. In this regard, there is a specific provision in the 1976 Act which give the right to non-Muslim couple to dissolve the marriage after 3 months from the period of the other spouse conversion to Islam. Okay, next. The question resolution the arrest is those the other issue by the civil court applied to the party who convert to Islam since he is embraced Islam. If the solution of the marriage is not made by party who did not cover to Islam, is the marriage still considered to exist from the point of view of civil law, even though the equation has take place to Islamic law.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Afham bin Muhammad Razali. My matric number is 074578. In my part, I'm going to talk about Sharia law and agreement in dissolution of marriage upon conversion of religion. In the context of Sharia law, the conversion of religion in marriage, whether by the husband or wife, is a complex issue involving aspects like punishment, marital status, and individual right. Therefore, in order to understand Islamic law related to religion conversion in marriage, we need to refer to the main agreement that include aspect of law and justice in Islam. Here can be stated a verse from Al-Quran from Surah Al-Baqarah verse 256. This verse affirm the principle of freedom of religion in Islam, which means that a person cannot be forced to embrace a particular religion. However, conversion of religion in the context of marriage also involve consideration of Islamic marriage law, which stipulate certain condition. Now we move to time when dissolution of marriage happen. The dissolution of marriage happen either one of them, where the wife or husband embrace Islam, or after the wife finish her iddah. However, if the wife embrace or her husband embrace Islam during her iddah period, then their marriage will remain and there will be no dissolution of marriage. Scholars do not have a definite consensus on the period when the dissolution of marriage take place. However, in Malaysia, we use mazhab Syafi'i. What he say is, if the wife convert to Islam before intercourse, then their marriage dissolve instantly. However, if the conversion occur after the intercourse, the marriage continue during the wife iddah, which no immediate dissolution. If the husband convert during the wife iddah, then marriage persists. And however, if he does not convert by the end of her iddah, the marriage conclude abruptly, which means they have to dissolution their marriage. Now we move to the last part, which is agreement from Al-Quran and Hadith about Muslim and non-Muslim cannot continue in marriage. First, we take from the Al-Quran from Surah Al-Mumtahanah verse 10. This verse states that when there is a difference between religions, a marriage cannot continue in Islam. For example, if the husband who converted to Islam, then he cannot be with his wife who is not a Muslim. The same is true for the wife. If her husband does not convert to Islam, then she cannot continue to stay with her husband. The second evidence is from the hadith narrated from Ibn Shabramah. He stated that in the time of the Messenger of Allah Subhanahu wa Ta'ala, if either the husband or wife embrace Islam before the other, and the husband convert to Islam before the end of his wife iddah, the marriage persists. However, if the husband convert to Islam after his wife iddah, the marriage is dissolved immediately. From these two pieces of evidence show that Islam obligate to dissolve a marriage if the spouse, one of the marriage couple, does not embrace Islam. That's all from me. Thank you.
My name is Muhammad Amir Aiman bin Rohizat, 073429. I will present about jurisdiction of the court to ascertain the dissolution of non-Muslim marriage in conversion cases. Family law relating to non-Muslim is governed separately from family law relating to Muslim. The Civil High Court have jurisdiction over family matters relating to non-Muslim in Malaysia, whereas Sharia Court have jurisdiction over family matters relating to Muslim. So there are two courts in Malaysia, which is Civil Court for non-Muslim and Sharia Court for Muslim. Based on Civil Court, under Law Reform Act 1976, in Section 51, the marriage will be dissolved if a non-converting spouse petition for divorce. And based on Sharia Court, under Islamic Family Law Act 1984, in Section 46, it say the conversion to Islam by either party to a non-Muslim marriage shall not by itself operate to dissolve the marriage unless and until so confirmed by the court. The court herein refers to Sharia Court. So we can say for the Sharia Court, the marriage will be dissolved if the other spouse did not convert to Muslim within the period of iddah. Thank you.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi taala wabarakatuh. My name is Aisan Najmi bin Ahmad Syarul Nizam, and my metric number is 072656. I want to present about topic the right to apply for dissolution of marriage due to religious conversion. So presently, under the law, the right to apply for divorce is only given to the non-convert party. From Section 51(1) of the LRA Law Reform Act 1976 clearly states that when one party to a marriage has converted to Islam, the other party who has not converted may petition for divorce. However, the petition can only be presented before the 3 months expiration period from the date of conversion. In the case Subashini anak perempuan Josingan versus Saravanan anak lelaki Tangatore, Ni Hashim J states the wife petition was filed in contravention of the requirement under provision to the section 51(1) of the 1976 Act. In that, it was filed 2 months and 18 days short of 3 months after the husband's conversion to Islam. It is submitted from the above provision that if the non-Muslim party refuses to petition for divorce under section 51(1) of the Act, the couple are still husband and wife bound by the formal law. It is understood that conversion to Islam neither determines nor automatically dissolves the marriage. This is different under Sharia law, where conversion of the non-Muslim party to Islam will automatically terminate the marriage. Okay, next. The effects of Section 51(1) of the LRA 1976 is explained further in the case of SYI Viswalingam versus the government of Malaysia. In this case, the appellant married Viswalingam Ponia according to Hindu rites, and the said marriage was registered on 15 November 1950. Viswalingam Ponia embraced Islam on 16 July 1978 and adopted the name Abdul Hamid Abdullah. Viswalingam was pensioned under the Pension Act 1980. He died on 7 January 1958 in a later date 7 March 1985. He died on 7 January 1985 in a later date 7 March 1985. The plaintiff applied to the Public Services Department for derivative pension. On 16 April 1986, the Pension Department rejected the plaintiff's application of the same grounds as stated in the statement of defense by the husband. In another case of conversion to Islam, the High Court in Neng Siu Pian versus Abdul Wahid bin Abu Hassan, Kadi Daerah Bukit Mertajam and Anor arrived at a similar opinion. It was held in this case that the Kadi has no right to annul the marriage, as it was contrary to the law and thus it has no legal effect. The court further said that conversion will not automatically determine the marriage but only provides a ground for divorce under section 51(1) of the LRA 1976. Another relevant section to be discussed in the section is section 3.3 of LRA 1976, which states that the act shall not apply to a Muslim or to any person who is married under Muslim law. In lecture me versus Ramadesan Wabrah J is of the view that section 3.3 of the LRA 1976 precludes operation of the provision of section 77 of the same act to the Muslim. However, in the Tesiu Chu versus T. Hua, the court pointed out that section 3.3 of the LRA 1976 was applicable to the convert spouse, as the parties were married under the LRA 1976. The decision in Tesiu Chu case was followed in the case of Johan Fairbairn Abdullah, where the court held that a convert spouse is still subject to the LRA 1976. So that's all from me. Assalamualaikum warahmatullahi taala wabarakatuh.
Okay, next for example case for this topic. First, about a Peli versus Majlis Agama Islam, Pulau Pinang and Ana, 1990. Second, the case Tan Sung Moi versus Tu Myu Kim, 1994. Third, Eswari Visungam versus Government of Malaysia, 1990. For New Siopian versus Abdul Wahid and another, 1992. And five, and last, Isabella Madeline Roy and Oz versus Sarimah Law Abdullah and Oz 5. So this is 5 example case about this topic, about the jurisdiction of the court. Can you review the case so we can get a more result and from the judging about this case.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Rafiuddin Jafri. My matrix number is 074548. So today I will talk about the conclusion of dissolution of marriage upon conversion of religion. The dissolution of marriage upon conversion of religion can be a complex issue as it often involves the intersection of civil laws and religious laws. Here are some key points. First of all, in some jurisdictions, the conversion of one spouse to a different religion does not automatically dissolve the marriage. Second one is in Malaysia, the family law deals with the area of divorce settlement upon conversion into Islam. The main intention of this research is to make a fair comparison, which court has jurisdiction to grant a divorce and which family law could be applied for granting the divorce settlement to both parties. Third, in Muslim family law, a Muslim cannot marry a non-Muslim. So, upon conversion, the marriage becomes invalid after a fixed period. The Law Reform Marriage and Divorce Act 1976 in Malaysia recognized conversion to Islam as a ground for divorce. 4. The converting spouse is not allowed to petition for divorce. He may appear in the civil court only in response to the proceedings initiated by non-Muslim spouse. Lastly, if the non-Muslim spouse does not petition for divorce, legal issues may arise regarding the estate of the Muslim spouse and the rights of the Muslim who has married the converting spouse. That's all from us. Thank you.